7:35, and this is Tuesday, August 5th, 2014. Since we've closed the public hearing at our last session, this is actually the start of the deliberations on the application of Global Tower Assets LLC and New Singular Wireless PCS LLC for the proposed personal communication service at 207 and 225 Lincoln Street. So, how shall we begin? I just want to make a record. We are recording this, but we've closed the hearing. We will not be accepting any new testimony or public statements at this time. So this is purely a session for the board to discuss the matter and vote on the. That's what we're going to do this evening. So.
Okay.
And just so the record is clear, we had asked the applicant at the last hearing if they would be willing to keep it open to allow for additional input from the public or from the applicant as we did our deliberations, and they expressly said they did not want to keep it open. So we are bound by that decision, and unfortunately we will not be able to accept public comments here.
So, gentlemen, how to begin? We've got an extensive record. We've all spent many hours sitting here and going over the material that has been submitted both by the applicant, our independent engineer, and by members of the public. We've got a number of requests for variances and approvals under the bylaw, but the findings we need to make are really shaped by the provisions of the Federal Telecommunications Act, and we should probably start there.
Actually, I was going to recommend the opposite, which is
Okay.
that we start with an analysis of the applicant's request apart from the Telecommunications
Okay.
Act, because if in fact we were able to address their concerns, grant a variance, or do whatever else they wanted without invoking the Telecommunications Act, we wouldn't need to do that. So I think we need to focus on the state and the state regs and the local bylaw,
Okay.
work our way through that, and then, depending upon how that goes, go the next step of the Telecommunications Act. That would be my recommendation.
I think that sounds great.
I will defer to your legal expertise. So, do we want to, I guess I just need the folder so we can at least read what the relief sought is, because my memory's not that good. So they have asked for, among other things, a use variance from section 5E,
Right.
paragraph 4, dimensional variance from the setback requirements of section 5E, paragraph 7D, and a special permit A2 under section 5E, along with a waiver of the 100-foot maximum height requirement under section 5E, 7C.
So let's
So-
take each of those in
Correct.
turn and see if apart from the Telecommunications Act, we would be able to grant their
Well, let's
requested
go.
relief.
Let's go with the first one then, the use variance.
So, if it's a use variance, then we're at 40A Section 10 of the state statute. And the burden would be on the applicant to show that owing to circumstances relating to the soil conditions, shape, or topography of the land or structures, and especially affecting the applicant's land or structures, but not affecting generally the zoning district in which it is located. That's the first prong. The second, a literal enforcement of the provisions of the ordinance or bylaw would involve substantial hardship, financial or otherwise, to the applicant. And that third, desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent or purpose of the bylaw. So those are the three criteria that we would need to satisfy for the first element, which is the use variance.
I don't think there's anything extraordinary about the shape or topography of the lot, particularly in, or even in conjunction with the proposed siting of the tower, that would allow us to meet, the applicant to meet the first test.
And I asked during the hearings, and I asked several times during the hearings, if there was anything about the soil conditions, shape, or topography of the lot that would prevent the applicant from moving the proposed cell tower from its proposed location, which is in the residentially zoned area, outside
Correct.
to a different part of the lot.
Right.
And what I heard is that they couldn't get a lease if it was going to be in a different location, but that there was nothing that they identified dealing with soil conditions, shape, or topography that would have prevented them from moving the proposed cell tower.
Correct, and since we're limiting this initial review to our local bylaw and the state bylaw, we're gonna look at the site as an entire site.
Yes.
And it's not just the area that the landlord said they would make available for this. We would look at the entire site and look to see if this facility could be sited anywhere on that site. And so, but even again, back to the first criteria for the variance test, it's a large site. There's a lot of different areas on the site that are, flat, that can be accessed. And I don't think they can demonstrate that this site is uniquely challenging to qualify for variance.
I agree. It's important, when we go through these points, that we cite to specific references in the record, because ultimately, when this is reviewed,
Right.
we will have to demonstrate that our decision is supported by the record.
Mhm.
So I just want to make sure
Good.
that
Right.
we're referencing those as we go through.
Yeah.
Again, on the issue of topography, soil conditions, there are specific questions that I remember asking, and those are the answers that I got. And is there anything else anyone can think of with respect to the record on this first point?
I don't recall anything other than what you just referenced that spoke to that point. I was going to say that I would not be able to find I would not be able to make that finding for this application. So,
Yeah, and I don't recall anything in the record that set this lot apart from its neighboring lots in terms of topography.
Or shape.
Or shape or soil
Right,
conditions.
right.
Do you-
Correct.
I don't believe that's in the
I
record.
don't recall
Again,
anything at all.
yeah, and again, it's the burden on the applicant
Right.
to, in fact, put
Correct.
that in the record.
Correct.
Okay, so,
Well, as you know, we have to make all four, so if we can't make the first, should we go through the other three?
yeah, I think we
Okay.
should.
All right.
And the second one is whether a little enforcement of the provisions of our bylaw would involve substantial hardship, financial or otherwise, to the petitioner. In terms of hardship, right now, the lot is being used in accordance with our bylaw.
Right.
Correct.
And I'm not hearing that if we don't grant the relief, the lot could no longer be used in accordance with the
Right.
bylaw. What I'm hearing is they need the relief to do something different.
Correct.
But it's not as if they would otherwise be deprived of the use of the lot.
Correct.
If we did not grant the variance. So I don't see how there would be the hardship finding.
I agree with
under-
that.
Right.
I agree with that.
Is that hardship, are you considering the landowner in this case or the applicant in this case? Because I think the applicant would not be able to use the residential portion of the lot.
The question is for the entity to whom the variance would be granted,
Correct.
and that entity is the landowner.
Landowner.
Okay,
Yep.
I agree.
The variance runs with the land, not with a
Yep.
licensee or a lessee
Exactly.
or anything.
That's right.
Okay. I would agree that I could not make that finding as well, so.
And then the final issue here is whether desirable relief
Derogation.
could be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent or purpose of the bylaw. And I think when we talk about the substantial detriment to the public good, we heard a lot of information provided by the neighbors. There were photographs, there were studies, there was anecdotes. that talked about a number of detrimental effects to the
Mhm.
public good if this
Yeah,
change.
yes, and we had some testimony by the applicant's appraiser that there would be no adverse impact on housing values. I think we found that testimony to be lacking. And then the abutters cited to a study, albeit from Florida, that used a more robust analytical technique, regression analysis, that showed that there was, in close proximity to a tower, a decrease in housing values. So we did have some conflicting testimony on the record. I happened to find the abutters presentation to be more persuasive on that.
I agree.
I agree as well. Don't really have anything to add on that one, so.
Emily, can you think of anything else with respect to the detriment to the public good?
I seem to be focused on the visual impacts and the value on impact,
Right.
the impact on values.
Right.
And I think it's not just the effect on housing values, it's also the general effect on aesthetics, which is allowed to be looked at as long as it's not just conjecture, but it's supported by, again, testimony at the hearings, photographs, and we certainly had that in the record as well.
And we also did have some discussion about whether or not we would have mounted antenna arrays on the pole or a
Right.
monopole. And we got pushback from the applicant on the monopole in terms of its ability to accommodate co-location. And so I think, the application assumed that you'd have a mounted array on the pole, which
Right.
is a lot more visual impact than a monopole that could have been alternatively proposed.
Just so we're using the right language, I believe
Or unipole?
It's a unipole.
they have proposed a monopole, and the alternative is the unipole or flagpole.
Thank you. Right.
Right.
And in fact, the unipole would be less impact.
Correct.
Got it.
And you were right that they specifically rejected that as an option.
Right.
I mean, just from a general looking at it perspective, this is not a situation where we have an applicant, namely the landowner, who's deprived of the use of his land. I'm really not seeing where we could issue a use variance.
No.
And we've had use variances requested in various circumstances, and we uniformly are quite hesitant to grant them.
Correct.
There needs to be substantial
Correct.
evidence that would allow us, the Massachusetts courts generally support zoning boards of appeals in denying use variances.
Right.
And I think we're adhering to both the spirit and letter of the state law and our bylaw in not going forward with
Right.
that.
I agree.
Yeah, in support of that, I can think of only one instance in more than 20 years on the board where this board has granted a use variance. So they're very rare, very
Yeah.
difficult to obtain.
Yeah,
And I
and-
think quite rightly so. So,
And the reason I point that out and needs to be in the record is it's not as if we are singling out this particular applicant
Correct.
for denial of a use variance, and that we are generally granting them
Correct.
in other circumstances, or that we're singling out cell towers as a group in terms of not doing use variances. We just don't do them because they really involve significant derogation from what zoning otherwise would provide.
Correct.
And we do not sit here as town meeting. We are the zoning board of appeals.
Use variances are a de facto rezoning, and that's one of the reasons that we are so hesitant to
Yep.
approve them.
Okay, so I'm satisfied that they haven't met their burden on
Right.
the first. And now what's the second request?
The second request is a dimensional variance from the setback requirements of Section 5E, Paragraph 7D. That is essentially the fall zone requirement.
Yeah.
Tower shall not be erected nearer to any property line than a distance equal to the vertical height of the tower, inclusive of any appurtenant device measured at the mean finished grade of the tower base.
Okay, so that is which letter?
D, 7D.
Right. I've seen other communities have fall zones at 120% or greater.
Right.
And I think our bylaw is appropriate in saying it's the height of the tower.
Right. And I believe you specifically asked if the location of the tower could be shifted in the back to comply with this provision, and they said no. We wanted to move it in a easterly direction.
It was,
Right.
it was moved somewhat from the original application.
Right,
So it's farther away from the residential property to the west.
right. So in
But still
terms of the
within
fall
fall
zone, we would have, I think my recollection is we asked for the move, I believe it's because that could have, among other things, it would have allowed the pole to fall on the landowner's property and not on an abutting property.
Right, but even as moved, the fall zone of the proposed tower would still go onto a neighboring property.
It would, okay,
Yeah.
okay.
Am I correct on that? That they didn't move the tower sufficiently
Right.
to avoid
Correct.
the fall zone going onto a neighbor's property?
That's correct. It's about 120 feet tall, and the proposed setback is approximately 80 feet.
Okay. But when we were asking for that to test if we could move it in an easterly direction, we were going to, I thought, move it sufficiently so that it would actually, we were going to move it more than 40 feet in an easterly direction behind, and I think it would have been able to be self-contained.
They did relocate it approximately 15 feet
Right.
towards the
I mean,
interior of
after
the site. And
that.
after
Subsequent to that, we made a,
They
right.
suggested that they instead would comply with the 50-foot no disturb zone required under the conservation bylaw instead of the zoning setback requirements.
Correct, and that was, I think, the first time that I had sort of mentioned that before. If they were asking for all these variances from the zoning bylaw, why not just ask for a variance from the wetlands bylaw? If it's going to fall onto a property, at least it can fall onto an unoccupied and undevelopable property rather than a residential property.
Yep.
Even though admittedly the chances of the tower falling are slight, they're not zero, so.
It's not clear that they demonstrated how slight they are.
Correct.
But what I'm hearing, let me ask, what is the distance from the cell tower to the closest residential property? Is it 80?
Property line is, I believe, 83 feet.
Right.
To the nearest residential structure, it's greater, but we measure setbacks to
No,
property
so I'm asking
lines.
from the property. Is it 83? Is
I
it
think
80?
it's 83, but I would need to verify. The plans are actually in that folder. Yep, thank you. They're saying 81 feet plus or minus.
So the closest residential property would be 81 feet from the cell tower.
Yes.
Is that the center of the cell tower, the outside? Because the cell tower has a width to it.
Correct. It appears they're measuring it from the outermost point
Okay.
of the structure.
Okay, so 81 in the cell. Okay. Because I know there was some discussion about the cell tower, if it was to collapse, it wouldn't necessarily go all the way down. It could collapse down to the
Right.
center, and there would be some sort of dispersion zone.
Right.
I think it's the upper 37 feet
Right.
is designed to break first.
Yes, but just looking at percentages, it's about 1/3, 2/3. So about 1/3 of the fall zone is going into the neighbor's property. And 2/3 stays on this property. So we don't need the full 120. All they need is basically a little more than 2/3 of the tower to somehow fall, and it's going to go onto the neighbor's
Right.
property. It's clear what the purpose of our bylaw, what the intent of the bylaw
Right.
is here, is to make sure that 100%
Right.
it stays within the boundary of the subject property. They're not asking for, they're not coming to the 100%, they're not at 90%, they're not at 80%, they're not at 70%. They're about 66, 67%.
Right.
So, I mean, that to me, it's clearly a derogation of what the purpose of the bylaw is. And I don't believe that they've demonstrated in the record the safety that would be necessary to assure this board, as well as the neighbors who could be affected, that there won't be a problem.
Okay.
But again, since it's a variance request, we need to go through those criteria. First one, owing to circumstances relating to the soil conditions, shape, or topography. So they would have to show that owing to circumstances relating to topography, soil conditions, or shape, the tower couldn't be moved further than, or at least 100 feet from an abutting
Right.
neighbor. And there's no
They-
topography reason why that couldn't happen.
Correct. There's a number of places on site that it could happen. Obviously, we don't want to see it in the middle of the parking lot, but it's a large site, and in particular, we're trying to protect the residential abutters. And there are other, they basically said that they didn't believe it could be, it wasn't feasible for them to do it anywhere else, but they didn't, it wasn't persuasive. They just didn't want to move it so that it could comply with this section of the bylaw, which is the fall zone.
Right.
Yep.
That was it.
Yeah, and I think they were straightforward, that they didn't think they could get a lease.
Well, I was thinking,
Yeah,
they said the landlord would not approve it,
Yeah.
but that's not
Right, that's not a zoning reason.
correct.
Correct. Correct.
Okay. So second, a literal enforcement of our bylaw would involve substantial hardship, financial or otherwise, to the petitioner, in this case to the landowner. I don't think there's anything in the record
Nothing.
to support that.
No, there was no argument about hardship
No, I think it's.
with regard to this
Right.
particular
Right.
provision of the
Right.
bylaw.
And then the final issue is desirable relief. Desirable relief may be granted without substantial detriment to the public good and without nullifying or substantially derogating from the intent or purpose of our bylaw. And what we're hearing is the opposite, that there would be detriment to the public good.
Correct.
And it would substantially derogate from the specific purpose of this bylaw.
That's
Correct.
right, this section of the bylaw, you're right.
Absolutely.
So I just don't see how we could
No,
grant that
Nope,
variance request.
right.
I agree.
As do I.
Okay, so what's the third?
I need legal ed,
Oh, sorry.
just to be sure.
Wait, we got something up there.
Get the legal ed. Waiver of the 100-foot maximum height requirement under section 5E, paragraph 7C, so the preceding paragraph of the zoning bylaw. So they've asked for 120 feet.
Right.
Bylaw allows 100 feet.
The bylaw says tower height shall not exceed 100 feet. The Board of Appeals may waive this restriction within the within the special permit A2 to allow for co-location, which will reduce the need for other facilities. And they did in fact talk about the potential for co-location.
Right.
They didn't have any particular users in mind, but they did talk about co-location. It would,
I think on this, because this is something we could waive, to the extent we had otherwise found that we could have granted a variance for the use and for the dimensionals and the fall zone and everything else. This is something that we would have probably been willing to encourage co-location and to potentially agree to adding another 20 feet so we could not clutter the town with towers. But given the fact that we've already come to the conclusion that we couldn't, we cannot grant either of the variances, this, I think, is just, this it becomes this becomes meaningless. I mean, we could waive it. I don't know that we, they're not asking for a variance for this because this is something we can waive without a variance.
You can waive if you were able to grant a special
If we
permit.
could do the special permit, right.
Yeah. So how do you want to handle
So
this?
I would say this is not a variance request.
I don't think it's a variance
Right,
request
it's
because
not.
we could waive it.
Right.
Yeah, so I would, but a variance request is deemed granted unless it's either denied or approved.
Okay.
So I think we would have to deny it as an improper waiver request because it really would be in the context of an A2, where it would be considered.
Correct.
And that's not a.
But isn't it automatically denied if we can't, if we've already denied the waiver for the use, or the variance for the use and for the siting with the dimensionals and the fall zone?
Mhm.
So isn't it automatically denied?
The fact that you and I could have this discussion gives me pause for concern, and I think we need to be explicit about
Okay.
it in
Okay.
the
Correct.
decision.
Okay.
Is it denied through the special permit? Do you go through the special permit criteria, or?
Special
Yes, so
permit,
they've
yeah.
asked for the special permit, and we will go through that criteria.
Correct.
But to the extent that they've asked for this as a variance, that they want us to vary the special permit requirement, in other words, that this should no longer be a requirement,
Yeah.
Right.
we are going to deny that because that's not
Yeah.
an appropriate variance request, and they can't satisfy any of the criteria
Okay.
Right.
for meeting
Right.
that variance
Okay.
option.
I think I should probably just, state here for the record, the language of the legal ad here, and because when they reference this 100-foot maximum height requirement, the full section of that sentence is in a special permit A2 under 5E, along with a waiver of the 100-foot maximum height requirement under section 5E.
Okay, so to the extent that they're talking about a
7C.
waiver within the A2,
Right.
then we'll get to it in the A2.
Right.
But to the extent it
Correct.
could be construed as a separate waiver,
Correct.
we should be specifically denying it.
Correct.
And I agree with you. I think it's probably just
Yep.
within the context of an A2.
Right.
Good.
Okay.
And in addition to the tower, they've asked for the 49 by 49 square foot fenced compound.
Right.
Mhm.
To what extent is the waiver request necessary for that compound?
I mean, if absent the cell tower use,
Yep.
it would be allowed by right. I mean, the fences are greater than 6 feet, but they comply with setback requirements in the district, so it would be
Okay, so
permitted.
we don't have to address them.
Right.
Okay.
Okay, good.
Right.
So then, they have asked for a special permit A2 under our bylaw. Emily, can you lower the temperature? Seems to be getting- Either that or there's too much hot air up here.
Right. There's an ice box when we first came in.
Okay, so where's our A2 criteria?
Page 5.
Page 5.
Page
Right,
5.
bottom of page 5. So 7 findings. First would be that the use of the site is in harmony with the general purpose and intent of this bylaw.
It's not.
It's not.
It's not, because we just talked about the need for the use variance or the request for the use variance. We couldn't find for that, so.
Right.
Right. The proposed use complies with the purposes and standards of the relevant specific sections of this bylaw.
It doesn't.
It does not in terms of the use and
I agree.
in terms of the height that they've requested. Specific site after the fall zone. The specific site is an appropriate location for such use, structure, or condition compatible with the characteristics of the surrounding area.
It's
Not.
incompatible.
Incompatible, correct. I agree with that. The use is developed and operated will create positive impacts or potential adverse impacts will be mitigated.
We couldn't make that finding because of the whole fall zone issue.
Exactly.
Correct. There will be no nuisance or serious hazard to vehicles or pedestrians.
I would say in its steady operating state,
Right.
that would probably be a fair.
Right.
Correct.
I agree with that.
Yes, correct. Adequate and appropriate facilities exist or will be provided for the proper operation of the proposed use. I think that, we can make that finding,
Yep.
yes.
Yep.
And finally, the proposal meets accepted design standards and criteria for the functional design of facility structures, stormwater management, and site construction. I think there's testimony on the record, and our independent reviewer, John Chesia, has agreed that I think we make those findings.
Yes.
So it
Did
makes,
they have to make any changes to accommodate Chesia or any other site plan issues?
I don't believe there's any outstanding that weren't incorporated into the planning board's site plan review decision.
correct.
Okay.
Okay,
So we found 3 of those, but not 4. So we know on 4 and a yes on 3.
So that means we cannot grant.
We cannot grant a special permit.
A2.
Right. Okay. Well, that's the relief requested from the bylaw.
Yes,
So,
so I don't think, absent the Telecommunications Act,
correct.
there would be any basis for granting the relief.
Right.
I agree.
Right. I agree
That
as well.
means we need to look at the Telecommunications Act.
Correct.
And I'm just going to go over some of the things that we need to be aware of. Because there was some discussion back and forth
With the applicant's counsel.
about what the Telecommunications Act provides. And the important thing, I think, for this board to understand is that in the statute specifically preserves local zoning authority over the siting and construction of wireless communication facilities, subject to 5 exceptions. We should talk about those 5 exceptions. The first one is the regulation of the placement, construction, and modification of personal wireless service facilities by any state or local government shall not unreasonably discriminate among providers of functionally equivalent services. So the first exception is
Unreasonable discrimination. Well, I'll go through all 5 and we'll go back.
Right.
The second is that the regulation of the placement, construction, modification of these personal wireless facilities shall not prohibit or have the effect of prohibiting the provision of personal wireless services. That's the second. The third is a state or local government or instrumentality thereof shall act on any request for authorization within a reasonable period of time after the request is duly filed. The fourth one is any decision by a state or local government shall be in writing and supported by substantial evidence contained in a written record. And then fifth, no state or local government may regulate the placement, construction, modification of personal wireless facilities on the basis of the environmental effects of radio frequency emissions, to the extent that such facilities comply with the Commission's regulations concerning such emissions. So the first issue is unreasonable discrimination among providers. There's been no discussion by the applicant, even a hint that we've discriminated against providers. And in fact, with respect to the other applications we've received with respect to this particular carrier, we've granted. Didn't we just grant an AT&T cell tower, or not, it was a placement in,
Generator placement, yep.
but where was the,
At 3 Elm Street.
Three to three.
Correct,
Yeah.
which was originally the
Right, so-
application at New North Church.
so I don't think there's been anything in the record.
Correct.
And I certainly don't know anything that would
Correct.
suggest discrimination. That was the first one.
Correct.
The second one is prohibit or have the effect of prohibiting the provision of personal wireless services. That's what we're gonna have to talk about.
Correct.
Let's go.
Correct.
The third one
Yep.
is that we have to act within a reasonable period of time. We've complied with the federal statute governing the timing. Emily, I think the applicant signed off on each of the extensions.
Correct.
And we had to close the hearing, and we respected their decision on that. So I think we're fine on the third criteria. The fourth is any decision has to be in writing and supported by substantial evidence. That's why we have the voluminous record that we have, and we are going to do it in writing, and we're going to do it timely. And the fifth is that we cannot base any action on alleged environmental effects of radio frequency emissions. There is nothing in the record, and I've heard no discussions
Right.
about that
Right.
as an issue,
Correct.
and that's something we've not considered in this case, and we're not going to be considering tonight.
We're not gonna be playing scientist.
We are not going to be playing.
I believe it may have been asked by a member of the public at a very early session, and we made it clear that
That's not something.
that's
that
not
we're
something
considering.
that we can talk
Yeah.
about, so.
So, the only issue under the Telecommunications Act that we need to deal with is whether or not what we're doing prohibits or has the effect of prohibiting the provision of personal wireless services.
Correct.
Other than that one exception, local zoning prevails.
Right.
So then we got to look at that issue. And under the statute and under the court cases, we're in the First Circuit Court of Appeals. When someone's invoking that prohibition language, the effective prohibition, the burden is on the carrier. It's not on us. The burden is on the carrier to show from language or circumstances, not just that this application has been rejected, but that further reasonable efforts are so likely to be fruitless that it's a waste of time even to try.
Right.
That's the legal standard.
You say that one more time?
Okay, the standard that they have the burden of proving is to show from language or circumstances, not just that this application has been rejected, this particular application, but that further reasonable efforts are so likely to be fruitless that it is a waste of time for them even to try. And so,
Fruitless because,
because there's no way that this board is going to be granting
Got it.
Right,
these applications.
correct.
And it's the same standard, whether it's the carrier, the landowner, the cell tower
Correct.
developer, it's all
Correct.
the same standard.
Okay.
So then we need to look at the effective prohibition. And the First Circuit has identified two sets of circumstances where there is a effective prohibition. The first one is where the town sets or administers criteria which are impossible for any applicant to meet. So we have such a restrictive, prohibitive bylaw, no chance anyone could meet the bylaw. The second involves a situation where the applicant's existing application is the only feasible plan to address a significant gap in coverage. In that case, then, a denial of the application might amount to prohibiting personal wireless service. So those are the only two circumstances. The first one is where the town's administers or has bylaws which are impossible for any applicant to meet. So let's talk about that. It's the first threshold. And
well, any applicant, we've already approved.
I was about to say, Emily,
Right.
We just approved an installation
Right,
for
right.
the same,
The same applicant.
Right.
And there have been at least two.
Or for the benefit of the same carrier.
Right, well, let me, how
Right,
many,
the same carrier.
how many commercial towers have we approved? Do you know? Cell towers?
I can
Whiting
think-
Street.
I can think of three.
Whiting Street, Sharp Street,
Yeah.
Main Street, and then this facilities on the smokestack, which in essence are,
Okay.
There's also-
And North Church now on Elm Street.
yes.
Yeah,
right.
Yep.
So the first, I don't think there's any credible argument that we have a blanket prohibition.
No,
We can just move past
Yeah.
that.
correct,
But we need to
Yeah.
make sure the record
Yes.
reflects that.
correct.
Let the record reflect it.
Thank you. So then the second criteria is that what they propose is the only feasible plan to address a significant gap. And what the First Circuit means by that is a town's refusal to permit a tower that is needed to fill a significant geographic gap in service where no service at all is offered in the gap. That's what would violate the effective prohibition clause. That's the First
Right.
Circuit definition.
Could you read that again?
Where a town's refusal to permit a tower that is needed to fill a significant geographic gap in service, where no service at all is offered in the gap. That's what violates the effective prohibition clause. So when a carrier claims an individual denial of a particular application is an effective prohibition, what they have to demonstrate, what the carrier has to demonstrate, is that there's a significant gap in coverage. That's the first thing. And second, whether there are alternatives to the carrier's proposed solution to that gap or not. And if there are no alternatives, then it would be an effective prohibition. So is there a significant gap? And are there any alternatives to what the carrier has proposed or what the applicant has proposed? So let's talk about the gap. With regard to the gap, a significant gap means the gap must be large enough in terms of physical size and number of users to distinguish it from what's called a statutorily permissible dead spot. Federal regulations contemplate that areas enjoying adequate coverage will include spots without reliable service. The regs specifically allow for that. Dead spots are defined as, quote, small areas within a service area where the field strength is lower than the minimum level for reliable service. And the presence of dead spots does not mean that service is per se inadequate.
Okay.
So that's the statutory, the regulatory, and the judicial standard that we're looking at. And this was all reviewed rather recently. There was a First Circuit Court of Appeals case, Green Mountain Realty Corp. Versus Leonard, that went over all these issues.
Yeah, that's the Milton case.
And, yeah, and so we've had discussions about the significance of the gap. And what we should look at, what the First Circuit's asked us to look at, is the physical size of the gap, the area in which there is a gap, the number of users the gap affects, and whether all of the carrier's users in that area are similarly affected by the alleged gap. So we should go over what they've talked about as the physical size, what that area is, the number of users affected. Yeah, and so that is,
This is information that we received back in June, well, it was dated June 9th
of this year.
of this year, so we talked about it the following evening on June 10th. And these are the numbers of users that would be covered that are not currently covered within the area that they've shown. Or the, sorry, essentially the length of streets, segments of the streets within the area that they were aiming to cover.
Yeah,
Along
I'm
Downer
not-
Avenue
But
and Crow Point.
the slip you made, I'm not sure if it was intentional or not. I don't remember seeing a number of users
Correct,
affected
right,
analysis.
which is why I restated
Did they
that,
provide
yes.
that?
They did, at the last hearing, I believe it was 275 properties.
Correct.
Are along those roadways.
Right. data just talks about the length
The
of the
length of the
streets
Do you have that?
within
I
that
just don't
area.
recall seeing that.
Right. And this is where this application got a little confusing in spots. We had testimony, the original application, 850 megahertz.
Mhm.
And then after we opened the hearing, 1900 megahertz was introduced.
It's time to print to the bottom.
Not only both the propagation models, but the drive time, the drive
Yeah.
test results.
So I don't see anything talking about the number of users. It tells me the number of properties,
Right,
whether they were inhabited or not,
yep.
wetlands or not.
Well, and also how many people,
AT&T customers.
reside in each.
Yeah.
I don't know that.
Well, but it's not reside. So for example, if the backyard is affected, but the main house is not, it's still one of the properties,
Right,
but we don't know how many users are actually affected by the gap.
right.
Was there anything specific?
Not
To
from the
that?
applicant.
Okay, was there something?
I believe the abutters presentation
Yep.
pointed to, from their drive test results, that they're, I apologize, I just don't want to misquote it. I know the end number. They conjectured based, I think it was approximately 130 properties, and then considering AT&T's market share of 32%, it was going to end up being like 12 properties.
I mean, usually when you're talking about a gap as opposed to a dead zone, it's, you've got significant people affected.
Not sure I'm not sure the market share concept could factor into this.
But the data we asked for several times and
Yeah.
never did receive was the data on drop calls. Is there a significant number of drop calls in this area?
Yeah,
As to speak to the reliability or the adequacy
yeah.
of the service.
And our radio frequency consultant, Ronald Gray, he submitted a report saying the applicant has not demonstrated
Right.
a significant gap, or any gap for that
Correct.
matter.
Right.
Um,
I mean, as we look at the testimony on this issue, there's a lot of conflicting testimony. We obviously have the applicant saying that they have shown that the 1900 frequency, if not the 850, that there is a service gap. We have our own radio frequency engineer who went back through and did an independent analysis with propagation tests and other tests that says emphatically there's no gap. We've had the abutters not only do drive test simulations on their own and record the data and make that data available to this board or the applicant if they
Right.
so choose, which is a great deal of data, as I understand. It's all digitally prepared.
Yep.
There's also representations on the carrier's website regarding the adequacy of the coverage. And they also use a testing mechanism, I forget the name of it, that's on their site that the abutters
Root metrics?
Yes.
Root
Yeah,
metrics,
right, root metrics.
that advertises that it accurately, that its methodology accurately measures the reliability and signal strength and that sort of thing. So we have a lot of conflicting testimony. We did take, this board did take the time to have an independent consultant who is qualified, who has designed cellular networks and helped implement them, independently assess the applicant's claim that there is a service gap, and he emphatically said there's not. And we can sort of go through all of the different data that's come in, but none of us three are radio frequency engineers. The abutters, notwithstanding all their hard work, they're not radio frequency engineers. They did do a very good job of documenting, and doing a lot of field research. And so it comes down to our radio frequency engineer who peer reviewed the applicant's analysis, and I'm inclined to go with our expert. We do have conflicting testimony, but based on the weight of the evidence, I don't think that they've demonstrated that there's a significant coverage gap.
Right. So the way this will go is that we need to make an assessment and make sure that our assessment is supported by substantial evidence in the record. But ultimately, if there is an appeal from what we do, and it goes to a district court, they will look at this de novo. They will not defer to us on this.
Correct.
But it's important that we, in fact, make clear our understanding of the information that's been presented in the record. I think
Correct.
you've fairly characterized
Yes.
what's going on.
I agree.
I mean, the gaps that I've seen in other cases, in other reported cases, you're talking about several thousand people over a significant geographic area that don't have coverage.
Correct.
We just did not have evidence
Right.
approaching that.
Right.
By any expert. And so it looks and smells like a dead zone to the extent that there's an issue here. I just haven't seen the data that would support a gap.
I agree.
Okay.
I agree.
I agree. I mean, if you look at these propagation maps, and it's not, I mean, there is a difference, obviously, but it is not a large area. It certainly isn't.
Yep. In the reports that we've seen from the applicant, they refer to a significant gap, but in my view, they're using significant as a conclusory statement as opposed to backed up by any hard data that they've at least shared with us. So I'm not inclined to agree that there's a significant gap. And one of the issues that goes to gap as well as alternatives is, what about the cell service that's coming from towers in neighboring towns, where they were a little concerned about, well, maybe we shouldn't be using them because we're not sure where the cell tower is, or it's coming from Hull or Weymouth or some other place, and it's not close enough to Hingham, or it's not in Hingham, that it should be considered. I did a little research, and in this circuit, there is case on point, which is the second generation versus the town of Pelham, First Circuit in 2002, where the Court of Appeals specifically held, in ascertaining the existence and extent of coverage for purposes of resolving an effective prohibition claim, we hold it permissible to consider the coverage provided from towers in other towns for purposes of making that analysis. And the fact that this carrier and this applicant did not want to consider those other towers is directly contrary to First Circuit law.
Right.
And
And
so-
also acknowledge that
Yeah.
those towers were providing service.
Yes,
They specifically acknowledge that.
yeah. So we are instructed by the First Circuit to consider those towers when we make the assessment.
Okay.
And so that points all the more to why we should not acknowledge that there's a gap here. So then we go to the alternative sites, which is the second prong of the effective prohibition. We had testimony from their site analyst, I think her name was Jackie, and she testified that they stayed away from any conservation land or wetlands.
Correct.
even though those properties might have addressed the gap, and even though those properties might have allowed for a cell tower with a fall zone that would not be on
Residential.
neighboring properties or residential properties. And she also testified that there was no written correspondence to document any of the inquiries made on the alternative sites. And in my view, that is an inadequate analysis. And the burden is on the applicant under federal law. The burden's not on the board, it's on the applicant to confirm that there are no other reasonable alternatives. And again, the First Circuit in the Green Mountain case said, and I'll quote, "The burden is on the applicant, as we've explained, for a telecommunications provider to argue that a permit denial is impermissible because there are no alternative sites. It must develop a record demonstrating that it has made a full effort to evaluate the other available alternatives and that the alternatives are not feasible to service its customers. The burden is on the carrier to prove that it investigated thoroughly the possibility of other viable alternatives before concluding no feasible plan was available." And we've gotten testimony on the record to the opposite, that they specifically did not look at other properties. And I'm just amazed that they proceeded as far as they have in these proceedings with that inadequate record. But I think even though the burden is on the applicant, we should consider what alternative sites are available. The applicant, the neighbors put a substantial effort into identifying other properties. I mean, the one that jumps out first is the smokestack at the shipyard.
At the shipyard.
Now, the applicant did address that in one of our final hearings. It may have been the final hearing, saying that the tower would need to be hundreds of feet taller than it currently is in order to provide comparable coverage.
Yes.
Which was a little astounding.
It was astounding, and I didn't see any analysis or support that would justify that conclusion. And we had our expert do an analysis, and he concluded, he found that an antenna located at 186 feet above ground level at the smokestack, where it was previously located, directed in the general direction of the purported gap, would in fact address the coverage.
Yeah.
So that was his conclusion based upon his analysis. And I just didn't see what the applicant provided to support anything different.
No, it was an oral representation that was made without any supporting backup. But given that the burden is on the applicant, we need to go through and, how much time do we need to spend discussing other sites when it's the applicant's burden and not ours?
It's important that we at least acknowledge that there are other sites
Okay.
that should have been considered. There was the school that was discussed, and there was also the property across the street from the school.
Zero
Yes.
planter fields?
Yeah,
Yes.
Plantersfield Lane.
And I didn't see anything to say that the applicant looked at that property and made any sort of determination that it was not feasible. And again, to the extent that there may be wetlands issues,
Right.
that's something that should be addressed with this board and with the Conservation Commission. And as Joe has pointed out, a cell tower falling on wetlands is probably preferable to falling on people. So,
Trees do that all the time.
yes, exactly. So I'm just amazed at the lack of the alternative analysis. And, you know, the evidence that the neighbors submitted, I thought was very powerful.
Correct.
And there's also the alternative analysis on this site, which is moving it out of the residential area.
Correct.
Which we had extensive discussions about. In my view, the landowner cannot take away the authority of this board to determine what's best for the town. And even under the Federal Telecommunications Act.
Well said.
So I think,
Couldn't agree more.
if the logic of the applicant was accepted, then in any application, they could say nothing's available because only these particular square feet are available for these.
Right, yeah.
And that would just
That
reduce
would-
to an absurdity.
Yeah, it would frustrate the act, the
Yeah.
intent of the act.
Yes.
Yeah. So I think there are other locations on the specific site of this property, as well as the smokestack, as well as the other properties that were identified by the neighbors. And in addition to the alternative location, there's also the question of the alternative pole. You mentioned up before the unipole versus
The monopole.
the monopole.
Right.
And we asked, I remember specifically asking if they would consider a unipole or that flagpole, and they rejected the unipole, and I asked why, and they said because it would not provide additional coverage for data and LTE service. And so while it might work for the issue that they're raising with us today, it would not work for data and LTE service. And then I asked the follow-up question is there anything in the record to suggest that there's a gap in service with respect to data and LTE? And the answer was no. They presented no suggestion that there's a gap. So on the record, there's no gap with respect to data and LTE. But on the record, they've rejected the lesser intrusive alternative of the unipole because it might not fulfill the data and LTE requirements for which there's no gap.
Right.
So that makes no sense.
Right.
And that's another reason they haven't met their burden with respect to the alternatives. I was just very disappointed in the presentation we received. Now, all of this Telecommunications Act analysis needs to go back into our variance analysis.
Right.
Because they've asked for a variance, and under state law, the hardship issues and everything else under our variance statute, let me pull that up again, needs to have a Telecommunications Act flavor. So we need to give the variance bylaw and act what the courts call a more inclusive view of hardship in light of the Telecommunications Act. So we should be considering whether or not they've demonstrated a hardship caused by, or that would be recognized by the Act, by the Telecommunications Act, as justifying a variance under state law.
Even if the hardship case could be made, if the other requirements
The
under the
findings.
act cannot,
The
where
findings.
does that leave the applicant?
Right.
Without a variance.
Right.
Exactly.
That's game, set,
Yeah.
match.
Yeah.
What the courts have looked at when we consider the location that's being proposed, and when we're looking at a request for a variance, is whether or not the proposed location, it's interesting, they've made three issues. One, is it centrally located within the gap, sort of giving that a unique status? Second, does it have the correct topography? And third, is it of an adequate size to effectively eliminate the gap in coverage? And what we know is that the proposed location is not
It's not centrally located.
within the gap.
No.
Right.
In terms of the topography, I'm indifferent about that. And it is not of an adequate size to effectively eliminate the gap in coverage, because even if there was a gap in coverage, where they pointed to is still going to exist to some extent, even
Right.
if they erect this tower as you go up towards the water. So this property doesn't have sort of the unique characteristics of being the only one available to satisfy the alleged gap.
Correct.
So it just doesn't bring it up to the level that will be required for a variance analysis. And as I said, and I think as we're all concluding, there are feasible alternatives that should have been looked at. So that's where I'm at. So
what I would do now, I'm gonna make a motion. If I don't get attacked by this
Attacked by that
flying insect here.
road fly.
And the motion would be, first, that the board conclude that the applicant has not shown that it would suffer a substantial hardship or meet the other criteria for a variance under the state statute, chapter 48, section 10, and that the applicant has not shown that a gap in cellular coverage would exist that could not otherwise be filled if permission to construct a 120-foot monopole tower at the requested location on the subject property was denied. And so, second, I would move that we deny the applicant's request. So the motion is first, that we recognize that the applicant has not shown that it would, that it meets the criteria for,
Right.
under the variance statute, and has not shown that a gap in cellular coverage would exist that could not otherwise be filled if permission to construct a 120-foot monopole tower at the requested location on the subject property was denied. And so therefore, we should deny the applicant's request.
I'll second that motion.
Okay. So this motion, it's been seconded. Any conditions we want to talk, or?
I don't think there'd be conditions associated
Okay.
with the denial.
Okay, it's fine.
Emily, anything else you can?
Anything else? Well, okay, there's been a motion, it's been seconded. All in favor?
Aye.
It's unanimous.
That's it?
Let the record reflect, unanimous.
Okay. Thank you all for showing up.
Thanks for
Thank you for your hard work and your
Thanks
great
for
presentation.
sticking with us.